Welcome to the Quorum Court meeting, Monday, May 22nd, 2023, Jefferson County Courthouse. Pastor Smith, would you lead us in a word of prayer, please? Okay, Madam Secretary, would you please call the roll?
Adams. Agee. Byrd. Curl.
Here.
Dumas.
Here.
Franklin.
Present.
Gaddy.
Here.
Hardin.
Here.
Holcomb. Jackson. Patricia Johnson.
Here.
Reginald Johnson.
Here.
Margaret Williams.
Here.
Next, we'll have the treasurer's report and Ms. Venetia Goodwin.
Good evening, everyone.
Good evening.
My apologies for not being with you all on last week for committee meetings. I had another meeting on that night. However, I did leave your treasurer's report, and I hope you all received them. For the month of April, your financials are, the beginning balance was $20,112,841.71. We had revenues for the month totaling $17,444,571.28. Expenditures were lower, $10,627,033.78, giving us an ending balance on April 30th, $26,930,379.21. I did not receive any questions from the last meeting, so are there any others tonight? Thank you so much.
Thank you, Venetia. Next, we'll have the reading and disposition of the minutes.
Judge, if I ask a question, please, before you do that.
Go ahead.
There seems to be an error in your agenda. Unfinished business was left off.
Okay. Unfinished business.
Can you insert that, please? Do we need a motion to do what?
Do we have any unfinished business? Yes, I entertain a motion to,
So moved. Second. Would you repeat that, Judge?
unfinished business was left off. Okay. Madam Secretary, proceed reading and disposition of the minutes.
Need a motion to second forward.
I entertain a motion in the second for the unfinished, which one are you talking about? Oh, on the minute. Yeah. Okay. All those in favor respond by saying aye.
Aye.
All opposed, like sign. Motion carries. Okay, next, the reading and disposition of minutes. No. No, that was unfinished business.
You moved and seconded. I think it was seconded.
now we have the report of the committees. Justice Holcomb is not here. Justice Harden, would you stand in? For-
Yes, Judge, thank you. We had one item on the agenda that was passed on to the full court with a due pass recommendation, and that concludes the report from the Human Resources.
Okay, thank you, Justice Harden. Do we have any comments or questions from the public on the business before us?
Judge, I'm not on that committee, but I believe that report was in error. There were 2 items on human resources. There were 2 items.
Okay, yes, there were 2
I would
items.
correct that. There was 2 items under one major Roman numeral, but there were 2. But we did pass the second one on to the full. I forgot which one it was.
Yeah.
We passed on the second one onto the full court with a due pass recommendation. There were 2 on the one heading.
Point out.
Okay. So the one that was passed on is the one we have before us
number
tonight?
2, right.
Number 2. Okay. Thank you.
In that, Judge, if I may, a point of order for clarity's sake. During the actual committee meeting, I think the motion that was made, they made a motion to rearrange the agenda and they addressed both items at the same time. I'm getting address both items at the same time. The problem with that being is that the vote came down to 4-3 vote, and for them to make a motion on an adopted agenda to actually amend the agenda, they needed a 3/5 vote, and so a 4-3 would just be a simple majority. They would have needed 5-3. So the question is, was the vote actually validated and passing it to the quorum court? Because by Robert's Rules of Order, the way that they voted it, it was a failure.
Justice Johnson.
In the committee voted for it to go. And Justice Harding said that since we had 2 there, he moved that we vote on the second one, which is what the committee did. And it was just a majority, not those who voted for that one only to go to the full court. We voted for the 7 to go to the full court for their vote tonight. Then they can vote on it, they can let it go. They can go whichever.
But
That was the one that we voted on. We knew we didn't vote on the other. We said we were not voting on, we weren't accepting the other.
for clarification purposes, the motion that they made and the vote that was taken, it addressed both issues. I tried to bring this and several other issues to the chairman's knowledge, but he said since I wasn't on the committee, no one on the committee that wasn't on the committee was allowed to speak. So we couldn't really intervene when it happened. But that brings us to the point that the motion wasn't a simple vote. It was a combination motion made that rearranged the agenda, and that requires a 3/5 vote. So at the end of the day, my question is, from a legal standpoint, a simple vote doesn't pass. It needed a 3/5, which would have been 5-2. So what do we do about this particular agenda item that technically didn't pass committee?
Justice Franklin, I'm gonna allow the vote to stand as 4-3. We're going to go ahead and move on with this. If you feel that this was not according to the rules that you saw fit, then we'll take that up at another time. But we're going to go ahead and move on with this. You can either vote it up or vote it down. So, do we have any comments or questions from the public before us?
I have a comment, not from the public, but from Justice.
Go ahead, Ms. Williams.
I'd like to make this little statement, and I wrote it out because I really want to say what I want to say. And so, to our judge and to all of our court members and to our public, I'd like to express myself here tonight about what I feel is an important statement to make. On January 1, 2022, I was sworn into the Office of Justice of the Peace, District 6, Jefferson County, Arkansas. A rather challenging 2-year campaign for the position did very little to prepare me for the actual seating at the table of this quorum court. On my first full night court session held January 9th, a new 2023-2024 court procedural
ordinance was voted down with a vote of 9-4. Prior discussions on the matter were pretty intense. County Judge Robinson stated that the matter could be voted up or down or go to review. At the time, Justice Carroll had been appointed chair of the Judicial Committee. Justice Franklin requested that the ordinance be moved from the Human Resource Committee to the Justice Committee. Persons serving as members of the Judicial Committee, were asked to assist with crafting procedural legislation for the court. As an appointed member of the Judicial Committee, I served with the committee. I assisted by studying Amendment 55 to learn what I need to understand concerning procedures and guidelines as it relates to county government. For 5 months, I have listened, watched, and experienced quite a lot. Much to my concern, especially related to the first ordinance and the new ordinance crafted by the February Judicial Committee. My silence has been met with questionable statements about my position on this court. While gaining a seat at the table may not always translate itself to having a voice at the table, I chose to listen and observe to determine from my thinking, and my thinking only, what can a 13-member court do to pass legislation that is solid and constitutionally sound, legislation that is procedurally accurate for the court, legislation that gives quality government for all elected officials, legislation that is good for our county, and legislation that is good for our constituents who voted us in. And that's my statement today.
Thank you, Justice Williams. We'll move on to, are there any comments or questions from the public on the business before us?
This is for public.
Yes.
Judge, thank you for this opportunity. I'd like to know if I could address or ask the county attorney a couple of questions. Check. I'd like to know if I can ask the county attorney a couple of questions, and I'd like to preface it with this statement, I guess. For almost 6 months, the Quorum Court has shown us just how unimperative they are to county functions and county operations. Nothing is hindered. The judge's staff is coming to work every day. Departments are coming to work every day. The judge is coming and they're carrying out assignments and etc. However, on the other hand, our community and taxpayers have spent, next month would be almost $60,000 on a Quorum Court that offers nothing for 6 months, almost 6 months in June. We've got absolutely nothing as a community. And I'm afraid, and I would like to not spend another $60,000 on a Quorum Court who doesn't offer us anything. So what are the options for the community to stop this financial bleeding? Can we suspend seats? Can we expel anything besides recall of some seats to get something from this Quorum Court? Yes, sir. Oh, well, thank you.
Thank you. Do we have any unfinished business?
Before we get into this meeting, is it possible that we could take these ordinances and sit down, we're already sitting down, and just draft a new ordinance that makes sense for both parties, all parties? Instead of voting up, we vote down, we vote up, we vote down. We have not yet sat down and tried to work it out as a collective group that meets all parties. We vote one up, we vote one down, and it's been going on for 5 months. And I think it's time for us to do that.
Justice Adams, I think that you are, that's an astute statement. And there have been many opportunities for us to sit down. I have extended my office. I have extended, the invitation to try to do this. Also, meetings held and to discuss things that I wasn't invited to. So, I mean, now in the presence, it seems that, now you're telling me that we'll sit down and talk about it. I am sure that at some point we will have to come to an agreement. And I will say this, and I want to say this to the public. I have made concessions to those who have come to me regarding these procedural ordinances. I've made concessions. And in doing so, the answers were still the same. What appears to me is that this is not a question as to whether this ordinance is where all parties meet. This particular ordinance has been in place for many, many, many years. And some of you same justices now says that it is a problem. It wasn't a problem in those years. And I want to make this statement. Where there were issues and decorum was talked about, the word emergency was talked about, those things were taken out. And so, again, it appears that it's not a question as to whether our ordinance is good enough or the ordinance that the procedures that the justices got together and wrote up. To me, in my opinion, it's not a vote against the ordinance. It appears that it is a vote against the position that's the county judges or against me. So the only thing that I can tell you is that as much as you guys put into it, was as much put into it by putting these rules in place through the county attorney and the Arkansas Associated Counties, just as well as anything else. And I must say that there are some things that budgetary restraints will not allow. There are some things, the format and all those things. But at some point, I've said all along that we have to have some rules and procedures in place. We have put ordinances in place and come back, and there are times where we may have added something, may have to take away something to make these things work. But the main thing is that it's not a closed door by passing an ordinance. It's not a closed door. We can always come together and talk. I've extended those opportunities. And in these last almost 5 years, had maybe a couple of people who would come and talk about or discuss any issues that they may have. In the whole 4.5, almost 5 years. So I've made myself available. I don't know how else I can do things. So in my view, I see this as not a vote as whether these procedural ordinances is not a qualified order or not legal order. I can only assume that this is a vote against Gerald Robinson, the seat. So again, that makes it personal. So whether you agree with me or don't like me, or whatever, we are here to do the business of Jefferson County. And I would like to see that done. And short answer, yes, if we don't get this done, along with the county attorney and the committees, we'll have to sit down and come up with something to get passed, because right now we don't have any procedural rules. And so there's no sense in throwing out Robert Rules of Order. There's no sense of throwing out what's right and what's wrong, because as long as we don't have any procedural orders, as the chair, whether you like to hear this or not, as the chair, I'm in charge of the meetings and have to make sure these meetings carry on. So there's been a lot of things said in these past 5 months, statutes being thrown out, whether true or not finished, when you speak of them, at the end of the day, we have to come together and, again, constitutionally, the county judge is the chief executive officer, and there are certain things that you have to go through the county judge, and you cannot circumvent that process. Justice Dumas.
I just wanted to make a statement, and I'm speaking for myself. I have nothing against the county judge. When we were in the full court meeting in February, it was voted 9-4 for it to go to judicial and for it to be reworked and brought back before the full court. That's what we did. And when we brought it back, it didn't get put on the agenda. And personally, I have been ridiculed on the radio, and now Reverend Johnny is saying, that we need to be expelled for having an opinion, because we did what we were asked to do, and it was nothing personal, because the vote was 9-4 in a full court. And I don't think it's fair for certain things to be said, or right for certain things to be said about quorum court members because they don't agree with the county judge. Sometimes the county judge doesn't agree with us. Most people don't agree all the time, but there's no reason to go after people because they don't agree. And no, it takes all of us, the county judge and the quorum court, to work together to get this done. I've asked the county judge about us getting together to get this done. We had a conversation Friday, and I asked you, would you be willing to go ahead and sit down and talk so that we can get this done to do what we need to do for the county? Yes, the ordinance we had was fine then. As you said back then, you have to have numbers in order to vote. There's no need for a person to say, well, yeah, I want to vote to change it. If you know you don't, you're not going to have numbers. And if you have numbers that you see that are willing to change, which showed in the 9-4 vote, that's why it was done. It wasn't that it was just pulled out of a hat to do. It was voted on to rework it and bring it back. And if there was a problem with it, it should have been put on the agenda so the quorum court and the county judge could talk about it and say, this doesn't need to be there, this doesn't need to be there, or can we come to a compromise? Yes, we have waited 5 months, but it wasn't just us. And everybody should be held accountable for it, not just the quorum court members who disagree. I just don't think that's right.
Okay. Justice Carroll?
Thank you, Judge. First of all, let me thank Attorney Wynn. He responded to my April 30th letter, and I want to thank you for what you said in that correspondence. That you said that clearly the Quorum Court has the authority to amend the agenda if done properly. And so I want to thank you for that response. But let me say this, since we are speaking from a historical perspective. The county judge was well aware that the procedure ordinance needed to have been drawn up in the January meeting. The procedural ordinance that was voted down 9-4 was an ordinance that was drafted by someone and submitted by someone other than an elected justice of the peace. The Arkansas Constitution says the only person that can put forward an ordinance or amend an ordinance is a duly elected justice of the peace. That did not happen. That item failed. There was a motion to send it back to committee for the February meeting. Someone already alluded to the fact that in January, I was asked to serve as chair of the Judicial Committee. After that item got sent back to the Judicial Committee, I was removed promptly. Justice Dumas was then named. The committee had already been given an assignment by the Quorum Court to meet and address this issue. We did do that. Invitations went out to the press, went out to the county judge, went out to all justices of the peace to attend the meeting. Because of certain circumstances, we ended up having to ask the sheriff to pick a meeting in his building. For different reasons, this building was not available for us to meet. And if you play the tape back, you will recall at the end of that meeting, when we adjourned the January meeting, as I was standing here and the judge was standing near where he's sitting now, I said, Judge, I will contact you to see if we can get an appropriate date for us to meet. The judge said, okay. He said, remember though, I select the committee members. And we laughed and we left here. A couple of days later, I was removed as chairperson of the Judicial Committee. Now, in the fact that all justices were polled to see if they had anything they wanted to share in reference to putting together this document, in the fact that the attorney was notified, in the fact that the Arkansas County Association, its attorney staff was notified, in that we looked at after the governor killed the.
Justice Carroll, Justice Carroll, Justice Carroll, Justice Carroll. I mean, I understand, Justice Carroll, that you've done. No, not Justice Carroll. It's Justice Carroll.
Point of order, Judge.
Justice
Point of order, Judge. He does have the floor until he relinquishes the floor.
Justice, nobody.
You can overrule him, but we will.
Justice Carroll, again.
Anyway.
You're
What
going.
was said on the radio was not true. We held the legal meetings, and this ordinance simply says, we cannot hold Zoom meetings unless the governor declares a state of emergency. That's what this ordinance says.
Justice Carroll, Justice Carroll, Justice Carroll. We're not here to discuss what was on the radio. We're not here to talk about what's on the radio. Justice,
Thank you, sir.
Attorney Wynn, you wanted to make a statement. I'm gonna let you make a statement, and we're gonna move on.
Point out to Justice Carroll, the numbering.
We're gonna move on. We're gonna move on.
Judge, point of order. You let
We don't
everybody
have a
else
point of order.
speak.
We're not doing Robert Rules of Order. It's not. We don't have it in place. We're gonna move on. So, no, it's not.
Can't just roll by it.
No, it's not.
You're just gonna do what you want to do. That's what. Just forget the quorum court. You just gonna do
I'm
what
not
you
gonna
want
argue
to
with you, Justice Franklin. We're gonna move on. It is my responsibility as chair to move these meetings on, and that's what I'm going to do.
Not the chair.
So, the county judge chairs the quorum court meeting. Well, I am the presiding officer, so I'm going to make sure that we move this meeting on. Thank you for the correction. So, as the presiding officer, we are going to move on into new business.
Old business.
Judge, I move that we have the ordinance before us. I've got the floor.
Point of order.
Judge, I move that we pass, that we have the title of the ordinance by title only.
Point of order.
We haven't even got there yet, Ted.
Point of order.
Yeah, we have, Alfred. We're just now in it.
Point of order.
I move it.
There are no point of order.
Justice Franklin, we're moving into new business.
Point of order.
We are moving
listen to my point, or everybody knows. Point of order. You have to stop and listen to what I'm saying. Point of order.
Under which rule?
Robert's Rules of Order.
We haven't established Robert Rules of Order.
So are we
Mr. Smart
going
Guy.
by Gerald Robinson rules?
No, we're going by the rule of.
Point of clarity, please address to the county attorney and ask him, are we still under Robert's Rules of Order?
We're not. We don't have any.
So we're just.
We're moving into new business.
We're trying to get some procedural orders.
We're moving into new business.
So how do we pass anything if we're not going by Robert's Rules of Order?
The statute allows the quorum court to meet and establish.
Did you wanted to do it by title only? Do we have a
Yes, I
second?
made the motion. We read it by title only.
We have a motion and a second. Madam Secretary.
Who's second?
AG, second. Item 1, an ordinance establishing and adopting procedures for the Jefferson County Quorum Court at all regular and special meetings of the Quorum Court of Jefferson County, Arkansas for years 2023 and 2024.
A motion has been made and properly second. Do you have any questions?
Oh, yeah, a lot of questions.
Justice Franklin?
You know, I heard the speeches that everybody gave, and I heard the speeches you gave. And, you know, one thing that I recognize is when somebody says something that's a play on words. You stated that there's a lot of things that goes through the county judge, but you never once stated what actually goes through the county judge. Legislation goes through the quorum court. That doesn't go through the county judge. We set the statutes, we pass the ordinances. If there's something that you don't agree with, you have a power called veto, where you can veto whatever it is the quorum court passes. But what we're faced with today is the fact that, and I hate to correct you, Justice Adams, you said that we voted on this prior. Our particular version, we've never voted on it. It's never made it to the quorum court level. It was placed on a committee level which was controlled by 4 people appointed by the judge to make sure that it never saw the light of day. So there's never been a discussion on the rules of procedure ordinance that this collective body, the supermajority, came up with. So what we have right now is a quorum court that is being controlled by 4 people at a committee level, at a bias committee level. So your particular ordinance that you worked hard on has never been voted on. Have you ever voted on it?
I was trying to put 2 on the table.
So there's a statement out there that said we've never had a problem before. We've always had a gentleman's agreement. It's always worked. Well, that's fine when you have a gentleman's agreement with people who are behaving as gentlemen. But when people step outside of the line of what the actual agreement is, there arises a problem. So if there's a problem with the particular ordinance that we put place, then we have to ask, what is the problem with the collective agreement that the whole quorum court or the majority of the quorum court came up with? At a certain point, looking at this particular ordinance here that's came to us, that's on the table right now, it's been here 5 months in a row. 5. It's been voted down 5 times. They knew when this came out of committee that it wasn't going to pass the full quorum court. But you have 4 people that is determined to try to push this through, and it's going to fail tonight. So when you offer that olive branch of communication or collaborating, it seems like the 4 that are voting against the majority's ordinance are the ones that should come up with the reasons why we should take something in the ordinance or out of the ordinance. Now, I want to say something. At a certain point, you got to start looking at the common denominator here. We got a quorum court here, and you telling me that out of 13 JPs, 9 of them are wrong. They can't get it right. They worked on this document. They are incapable of coming up with a legal document to govern the quorum court, but yet they're voting on legislation for Jefferson County. You're telling me that the majority of the countywide elected officials that support this document, they're in the wrong. So I ask you, who is the common denominator dealing with this?
You can look at common denominators both ways.
Well, let me say this, and I'll bring it to a close. At this particular moment, with this ordinance that's here, I make a substitute motion to strike the language in it and make it read as the majority language in the official quorum court's rules of procedure ordinance that was put together in the Judicial Committee and passed out that we want on the agenda. So let's strike the language in this one, replace it with the language from pages 9 through 19 or 10 through 19 on the actual manufactured rules of procedure ordinance by the quorum court.
I am not going to entertain that.
You can't use
the rules and procedures that you have in place. There are so many budgetary
restraints. What's the budgetary restraint? What is it? What's the budgetary restraint?
We're not going to get into that. What are we going to get into?
Well, here's what I can tell you.
Legal.
There is a county attorney.
No, I'm not.
Well, ask your county attorney.
I lean not to my own understanding. I lean to my county attorney.
Ask your county attorney. Is there a severability clause in the ordinance? Is there a severability? The severability clause. So if there's something that is actually in our ordinance that is not in compliance with the Arkansas Constitution, does it have a severability clause in the ordinance? Period. Last page.
I wrote an opinion letter to Justice Carroll Friday and copied you and every other quorum court member. But the document that you all are trying to substitute with has so many errors and incorrect statements of law, and it'll adopt a statute number and then misquote it. You all don't have a document that is fit for adoption as rules of procedure.
Come in, Drew.
Your rules, what you all are offering, not only tries to establish rules of procedure, but it tries to adopt substantive law, oftentimes misstating Arkansas law, and I've pointed that out that you can't do that. I've offered to sit down with Justice Carroll and anybody else that wants to sit down and try to go through and create a procedural order, but I've had no reaction from anyone. I still make that offer. You've got a document that's not appropriate for adoption as a procedural order. You can always try to correct it and provide it at a subsequent meeting, but what you've got right now is not a proper and functioning ordinance.
Judge, I challenge that.
We're not, we're not,
For him to show that.
Justice Carroll, we're not doing it, we're not in a, we're not in a court of law, we're in a quorum court meeting. So we're gonna get past this.
When can you meet?
Anytime you want to, that I don't have a conflict with my private practice, I'll be glad to meet with you.
Okay, and from that, go ahead, Justice.
Yeah, I've been a member of a lot of committees and boards and everything. I'm one of the ones that voting for ordinance number 2. But I've never been accused of being biased on account of the way I vote and what I vote's right. So I'll take exception to that. I consider myself a fair man. I try to be informed. And so I just want to go on record that I take exception to being labeled as biased for voting my conscience. That's all I have to say.
Judge, you gotta be recognized.
Justice Harden.
I agree with what Justice Agee just said. What I looked at is I looked at the 19 pages or whatever, however you want to say it, and the 2.5 pages. I looked at policy and procedures. The number 1 item that was on there had 19 items or 19 discussions about the legalities that the quorum court has. And the quorum court has a lot of power, and we have a lot of rules and regulations that we can go by. What we're trying to do tonight is talk about the policy and procedures to handle business. That does not mean that that would exclude anything that was in item number 1. It just means that that could be brought up and addressed. And in most instances, it doesn't have anything to do with the policy and procedures. It was a lot of it in there with just what we legally can and can't do. And I agree with a lot that was in there. But what we're trying to do tonight is just pass an ordinance to give us the right to pass laws and discuss laws and add to or take from whatever in a civil manner without hollering and screaming at each other or screaming at the judge or screaming at any JP, and just have a civil meeting that we hadn't had in 5 months. And I think the public is tired of it. I know I get comments about it all the time, is why can't we just settle it? The ordinance that's on the floor tonight is very concise, and it has to do with rules and regulations, the policy and procedures. It doesn't get into all what the quorum court is capable of doing, what the quorum court can legally do. It's just concise to get into where we can have an ordinance, and then if it's want to be adopted, and then if it's not adopted or if it's want to be revised, we can do that. But we need to get on with the county's business and then address anything else that comes up that we want to amend or refute. That's what I'm here about, and that's why I would like to see us pass this ordinance that's already on the floor.
Okay.
Yeah.
We're going to move on with this. We had a motion and a second.
Point of order, Judge. I have a comment. To address this comment, and I'll keep this brief, super brief. The reason we won't pass it is because the supermajority of this quorum court has been fighting to produce and put something on the agenda for the past 5 months. We have been lied to. We have been put off. We have been ignored.
Justice Franklin, Justice Franklin.
A hit dog will holler.
You are exactly right.
You telling me you didn't lie to Justice Dumas when you said he was going to put it on the agenda?
No, I did not.
You didn't say that?
What I did tell Ms. Dumas, I said at a later date. I didn't say the very next quorum court meeting. Now, there might have been a misunderstanding, but it was not a lie. And if Ms. Dumas would tell you, I sent her a text explaining to her that it must have been a misunderstanding because that's not what I said.
I asked you a question and you said yes. I said, would you put this on the agenda? You said yes.
You said it to us in the quorum court meeting.
I did not. Look, I said.
Floyd got the tape.
I said that when you pass this, I said, and then we come back and we talked about, and I said, let's pass this, and then then we can bring that back at a later if you want to revise it or whatever. I did tell you that. So I'm not going to go back and forth on that. What I am going to do, I'm going to call for this vote.
And it's
And
gonna
if
be
the
voted down.
supermajority votes against it, the supermajority votes against it. So we're calling for a vote. We had a motion and a second. All in favor, respond by saying aye. All opposed, like sign.
Nay.
Madam Secretary, call the
Adams.
roll.
Adams? Okay.
That is very difficult.
Justice Adams, just vote how you feel. Vote your conscience.
Yeah, I won't vote my conscience, but
Yeah.
I've asked you tonight to put these two ordinances on the table. And let's look at it. And you failed to do that. So we leave us no choice. We leave no choice.
Well, they were put on the table before the committee, both ones.
Nah, don't lie like that. Don't do that. Don't do that. Don't lie to this Quorum Court now.
Justice
Now, I
Franklin.
maintain my composure,
Justice
but don't
Franklin.
come in here and lie to this Quorum Court
Justice
like you put
Franklin.
it out there for us to discuss
Justice
it.
Franklin.
You did not. You put it in front of a committee where your 4 people shot it down
Justice
and wouldn't
Franklin.
let us speak. Don't sit up here and lie to the public like
Justice
that, man.
Franklin,
Jefferson County is looking at you.
Justice Franklin,
Why
don't
you
stroke
just
out.
coming
What are
here?
you doing? Why you all
Just
upset?
Don't lie to the Quorum Court
Don't
like
stroke
that.
out. Let's
Don't
that's
do
why,
that.
That's exactly why we call for the vote.
Oh, man. Don't do that.
AG? Oh, Adams? I'm sorry. Okay. Okay, I'm gonna come back to you. Bird? I got. Huh? I can't hear. Yeah. Okay. Carroll?
No.
Dumas? Franklin?
No.
Gaddy? No. Hardin?
Yes.
Holcomb? Yeah. Jackson? No. Patricia Johnson?
Yes.
Reginald Johnson?
No.
Margaret Williams?
No.
Now, before you adjourn, I have a separate item here, if you can address this. This is from the sheriff.
Meeting adjourned.
Don't you have to have a vote? And a
We don't
second?
have Robert Rules of Order. Meeting adjourned.